Can you legally force your ex-spouse's parents or siblings to hand over their private bank statements during a bitter divorce in British Columbia? Welcome to This Explainer. Today, we're unpacking a high-stakes legal battleground, the intense conflict between uncovering hidden wealth and protecting the absolute financial privacy of third parties.
I mean, it sounds like an incredibly powerful shortcut to uncover hidden assets, right? But is it actually possible under Canadian law to drag your in-laws into your divorce proceedings just to trace money? Well, the short answer is yes, but it is incredibly difficult, and the law puts up some major guardrails.
Section 1. The baseline reality, the absolute duty to disclose. To understand how those guardrails actually work, we really have to start right here at the baseline. Before anyone can even think about going after a third party's financial records, we have to look at the rules the spouses themselves must follow. Under Section 5 of British Columbia's Family Law Act, spouses owe a general duty to disclose full and true information. This isn't just a polite suggestion, guys. It is literally the bedrock of the entire family law system. As the Supreme Court of Canada stated in the landmark case of Michelle versus Graydon, spouses are subject to a duty of full and honest disclosure comparable to that arising in matrimonial negotiations. Honestly, without it, the system simply cannot function.
So, how is that duty enforced in the real world? Enter the Form F8 financial statement. If you think doing your annual tax is a headache, oh man, the F8 is on a whole other level. It's a mandatory, sworn document that's required the very second there's a claim for support or property division. And the requirements are massive. We're talking 3 years of personal tax returns, assessments, pay stubs, and if you happen to run a corporation, 3 full years of corporate financials too. It is an exhaustive baseline that serves as the absolute starting point for tracing any disputed money. Section 2. Compelling third-party documents, the high bar. But what happens when that standard F8 just isn't enough? This is where things get really contentious. Let's say you've received your ex's F8, but you strongly suspect they're actively using a new partner's bank account or an in-law's business to hide money. How do you get that information? Under BC Supreme Court family rules, specifically Rule 9-1 Subrule 15, you can technically use a third-party application or a trial subpoena to demand financial records from non-parties, like banks or in-laws. It sounds like the ultimate weapon, right? But getting this granted is a massive uphill battle. The biggest hurdle here is that Canadian courts strictly protect third-party privacy. You absolutely cannot just go on a speculative fishing expedition based on pure suspicion, meaning you can't demand your ex's mother's bank statements just to see if anything is there. That is strictly prohibited. Instead, to breach that privacy wall, you are required to bring objective evidence of relevance. You need hard facts. To actually win this order, you have to run a really strict procedural gauntlet. Step 1, you must apply on notice to the third party. You have to officially serve the in-law or the business, giving them a fair chance to show up in court and fight back. Then, you must provide solid, objective evidence proving 2 very specific things. Step 2, that these hidden financial documents actually exist, so no guessing allowed. And Step 3, that they are directly relevant to a major issue in your case, like child support or asset division. If you can jump through all these hoops and prove they're using family accounts to hide money, the court will step in and order the records produced. Section 3. The hammer. Severe penalties for hiding assets. Let's pivot for a second. What if a spouse decides to play games? What if they hide or refuse to disclose, lie on their F8, or actively try to circumvent these discovery rules? Well, the family law system definitely has an answer for that, and it is severe. Judges can drop some incredibly heavy legal hammers here. Under the Family Law Act and Supreme Court rules, a judge can impose fines of up to $5,000, order the lying spouse to pay the other party's legal expenses, or even completely dismiss their claims. Perhaps most significantly, they can attribute income, which basically means the judge artificially inflates your income on paper and forces you to pay support based on that much higher amount. And that brings us to a really crucial concept, the adverse inference. This is a devastating legal penalty. If you deliberately hide the paper trail or refuse to disclose, the court doesn't just throw its hands up and give up. No way. Instead, the judge is allowed to draw an adverse inference, meaning they will assume the absolute worst about your hidden income or assets. The judge will essentially say, look, since you refused to show us the documents, I am going to legally assume those documents would have proven exactly what your ex is claiming, and I am ruling against you. It is a massive risk for anyone trying to game the system. So we're left with this final, really provocative thought. Where exactly is the line between a third party's fundamental right to privacy and a spouse's right to a fair and honest financial split. As we've seen throughout this explainer, navigating these complex third-party discovery rules and tracing hidden assets requires high-level legal strategies. These challenging family law issues are precisely handled in Canada by an experienced divorce lawyer in Canada at Pax Law Corporation. Protect your financial rights and let professional legal experts handle the heavy lifting. Thanks for joining me on this deep dive into the realities of tracing assets in British Columbia.